Thank you, Shana. I thank Global Jindal Law School of the OP Jindal Global Law University for giving me this opportunity, and I feel privileged because I was also part of teaching community a few years back, I should say almost 20 years back. So naturally, I'm very happy when I meet students, when I meet teachers, or I visit the campus also, because I was very much part of the teaching community at Indore, and I taught law for about more than 12 years. I was a law teacher, I was a practicing advocate also, and researcher at Law Commission and draftsman at the Ministry of Law and Justice. So whenever the law is enacted, how it is enacted, drafting side, how it is practiced, practice side, and further research for reform, that research is required. So all the, I think, sides of the law I have seen, except the judicial side where I think judges deliver judgments. Otherwise, practical side and framing side, both I've been a part of that. I have gone through all the processes. So especially in the case of insolvency code also, I was part of BLRC committee. So I have seen how the policies were translated into the code of this insolvency code. And thereafter in the board, so how the regulator functions under this code and what are the duties of regulator. And from the government side also, I had the opportunity, and from the regulator side also I had the opportunity. So I think by God's grace, I was best placed. Not the best place as per my aspirations, but at least for the purpose of this course, no doubt, I've seen the framing and the enactment both. Policy framing and enactment. Now, as far as the insolvency bankruptcy code is concerned, Ishana, how much time I can have for this address?
You have 15 minutes, but
how many?
You have 15 minutes, but
okay,
we'll margin for more.
No problem. As far as the insolvency is concerned, it is a state of affairs, and it's a global in nature. Everywhere you will find that there are insolvency laws, and insolvency used to prevail across all the countries in the world. It's not that it is a new concept for us. Insolvency was there. I think in ancient times you will find that the insolvency was there, and I think I will just within seconds I will narrate you the episode during Mahabharat. Okay, after the after the war of Mahabharat, where Yudhishthira was going back, then he met Yaksh, and Yaksh asked that you answer 10 questions and then I will allow you to go further, cross this well or something like that. And Yaksh asked, who is the happiest person in the world? Then Dharmaraj Yudhishthira told, happiest person in the world is not who doesn't owe any debt to anybody. That person is the happiest person. Can you think of that? That time also, Nirini Bharat, Nirini Vyakti, that time also this concept was there, and Dharmaraj Yudhishthira answered that. I think that is the starting point. I mean, in India also, it was part of culture also. A person who dies indebted, I think his son, family, or family members who are kartas after, or who are successors, legal representatives, they are under duty. They owe an obligation or duty, or I think it's a religious duty that they have to repay the debt. So this insolvency is not that it's governed by law. Even culturally in India, insolvency, if you owe some debt to somebody, or you have to pay something to somebody, the amount which you have taken, then you need to pay back. And हमारे देश में culture है कि वो नहीं देंगे तो बैल बनेगा, नहीं देंगे तो कुछ और व्यक्ति इस तरह से आके ले जाएगा next जन्म में. That means this debt will continue in the next birth. Can you imagine कि this kind of culture was there, or as per mythology, this kind of culture was there, and still exists in India. And it was a kind of a stigma for, because if the insolvency resolution gets 10 years or 20 years time, or it is resolved within such a long time, then that stigma continues. Nobody will give you advance because this company is insolvent or this man is insolvent. ओ नो नो वहां तो नहीं देना हमको, अरे क्या देना उसको पैसा, उधर दिवालिया है. So that stigma continues. So this continuous stigma for a long time required a process, time-bound process. Required a process that this stigma should go away with, so that he can have a fresh start, fresh life. After independence, before independence, we had two laws: Presidency, Presidency Insolvency Act of 1909 and Provincial Insolvency Act of 1920. Those laws were adopted under the Constitution by presidential order after independence. As far as the corporates are concerned, provisions were there in the under the Companies Act for winding up. And one of the grounds for winding up was inability to pay debt. It existed since 1956 Act also. And later on, it was found in 2013 Act. But with the enactment of the Insolvency Code on 28th May 2016, that ground of inability to pay debt was omitted from the Companies Act, and then because the special law was enacted for this very reason, inability to pay debt under the Insolvency and Bankruptcy Code of 2016. You'll find that this insolvency is global state, and it is found both in individuals and the corporates. Corporates are juristic persons. So I should say it is found in all kinds of persons. Corporate insolvency or the individual insolvency. For your information, you all must be knowing that at present, under the code, we have two parts, part 2 and part 3. Part 2 deals with the corporate insolvency and part 3 deals with the individual insolvency. And we have enforced the corporate insolvency provisions, but we have not enforced the individual insolvency provisions except the provision related to personal guarantors. Because we don't have infrastructure, I think it's the infrastructure level, the district level or state level is required, which is a hard task. And though the provisions are there, but still infrastructure and other things are required to be, I think, to vary by the government, central government, state and both. In such a case, those provisions have not been enforced. And these two acts which relate to individual insolvency, they still continue. And the individual insolvency is still being continued by this. And we have Surface Act, we have Debt Security Tribunal Act. So both these acts are there. Now you'll find that after globalization, after 1990, it's more than the 3 decades that there is an increase in the global active business activities. We have more activities, even I think outside India also, and we have cross-border insolvency cases also. And Jet Airways and Videocon case, I think they're the best example of the cross-border insolvency, but we don't have the provision regarding cross-border insolvency except sections 234 and 235 in the code, which provides for bilateral treaty or agreement. As far as the insolvency is considered, resolution of insolvency, in earlier days or before prior to the enactment of the code, the insolvency resolution it used to be through the recovery process only, which was provided under the Debt Recovery Tribunal, or it was provided under the Surface Act. But after studying the debtor in possession model, BLRC committee came to a conclusion that since independence, we have debtor in possession model, but it has not served the process. Time taken is too long. Recovery rate is very, less, 28%, 4.5 years as a recovery time. So it has not served the purpose. And in business, time is the essence. You see the share market, time is the essence. So in business also, every moment, every day counts. And when you take credit, and especially after the consumer culture which developed or which was further promoted by the liberalized economic policy, this consumer culture led to the development of the credit culture. आप गाड़ी खरीदते हैं, आप कोई भी सामान खरीदते हैं, एसी खरीदते हैं, you have a loan system. Banks promote that, please इसको लोन से आप खरीद लीजिए. There is a system of, finance system जो देश का है, whatever system we are having for the purpose of GDP increase, there is a system that you spend more. And in this connection, you'll find that there is a lot of insolvencies also. People are not able to repay their debt, especially during COVID times. And when we are celebrating the 75th year of independence, I think we should try and make our all endeavors that we are debt free, or at least we are able to resolve the corporate debts, and corporates should come forward to have the corporate insolvency resolution so that we can have fresh start. When there is a lengthy time of recovery or resolution, what happens? Two things. I think adversely we are affected by two things. First is the asset value gets deteriorated. जो मशीन 5 लाख की है उसकी कीमत सिर्फ 50,000 रह जाती है. Asset value is deteriorated. The value of any asset which is worth 5 lakhs, it reduces up to 50,000 or 10,000. So it's meaningless. Even if you want to recover, you are not able to recover because of the time factor. Secondly, if the company goes into liquidation, then the livelihood of all the employees or workmen, it adversely affects their livelihood of maybe employees, maybe workmen, maybe other persons also. It also affects the operational creditors because they are supplying provisions, they are supplying articles. So their livelihood is also affected, not only the workmen or the employees of that company. So there is a big unemployment problem. So these are the two socio-economic effects. And because of these two socio-economic effects, actually it ultimately adversely affects the growth of economy also. Growth of economy or the GDP also. In this context, BLRC recommended Insolvency Bankruptcy Code. It recommended a system where not the CD who is indebted or corporate debtor, he will not be in possession of its assets. He will not be having control over the affairs of the CD. Person who is not able to manage properly and because of his mismanagement, this is the state of affairs of the company. Why should he have a possession of those assets? Let us give to some other person so that he can revive that. In this age of specialized knowledge, we require professionals. Even you celebrate a birthday or you celebrate any event, you require professionals to organize that event or the birthday or the marriage. Similarly, in this case also, when time is short, just think of when time is short, what happens? You give to a contractor, you outsource some services. Please, abhi kar dena is tarikh tak. Similarly, under this code also, we have provided, code provides for a professionally managed process with less intervention of judiciary. Earlier, it was judicial supervised process. No. In this case, what happens? Maybe a financial creditor, maybe operational creditor, or maybe a debtor. All three have been made entitled to make an application. No difference. Even the CD, corporate debtor, if he thinks that I should revive my company, let me go for that. And he can also make an application. Provisions are there under the code. So entitlement, who can make an application? Stakeholders have been given a free opportunity. But anyone who makes an application, then thereafter, after admission of the application, the whole process is collective. It's not that you file one application, the other files another application, and third person files another application, and there are bundle of applications, and judiciary will not be able to handle it. It's better if one files application, it will be a kind of representative application. If it is admitted, then the insolvency as such as a whole process, taking care, balancing the interest of all the stakeholders, would be done through resolution process of plan. So, एक साथ सबको हम बिठा के खाना खिलाते हैं, एक साथ सबको बिठा के हम सबके इंटरेस्ट को टेक केयर करते हैं. I think if one application is made, that fellow takes his pound of flesh, another fellow comes, he takes his pound of flesh, then the fourth or the last fellow, nothing remains. So that is also a big tragedy. And that is why under the Insolvency Code, anybody can make an application, but thereafter, after admission of the application, there is no role of the judiciary. The professional is there to take control, to take custody of the assets, to manage the day-to-day affairs. Now this professional, who is a qualified professional, who passes limited insolvency examination, who undertakes pre-registration courses also, he knows all about the Insolvency Code, the process, all about the process. he undertakes, he has to conduct the process, and he has to receive the claims, collate the claims. He has to prepare information memorandum. He has to put before the committee of creditors, which comprises only of the financial creditors. If there are no financial creditors at all, then the operational creditors, there is a process provided for operational creditors, COC also. But there is, but the COC, the committee of creditors, the lenders, the financial creditors, they are the members of the committee of creditors because they have given advance, they have lended the money. So they are the best person because at the time of advancement of the loan, they have finalized or they have approved the project report of the company. When they have approved the project report, naturally they are the best person to judge now how to progress, how to revive the company back. And that's why COC has been given the charge to decide about the company, to finalize the plan, and the resolution applicants in this code, I think after the amendment, there was an amendment, and this code, as we all know as students of law, there are principles of equity. And one of the principles of equity is that one should come with clean hands. So any person who wants to, who proposes a plan for revival, at least he should not be a defaulter, he should not be convicted, or he should not be indebted, or no NPA proceeding is there against him, or no NPA is there. I mean, there is a list under section 29A who are the persons who are not eligible. So persons who are eligible other than 29A, not disqualified in 29A, they all can make an application for the resolution process. They can submit their plans. And the best plan will be sanctioned by the COC. Time period given is for the whole process is 180 days. I think nowhere in the world you'll find that this 180 days now being extended to 180 days and 270 days extension. Further extension can be taken for 90 days. These are the two timings, 180 days initially and 270 days. But later on, through amendment, this period was increased to 330 days. In this 330 days, this period includes the litigation time because people used to file number of interim applications. I think some with a deliberate intention to intervene or to hamper the process, or sometimes because of the complication of the process, complication of the process. I think average time taken till date, including those cases where I think 2 or more than 2 years have been taken, the average time is now 450 days, but not in all cases. So 330 days includes the judicial litigation time also. So the moment the IBI or the government came to know about the shortcomings, inadequacies, some kind of mischief, some challenges, I think within this 5 years, we have seen 6 amendments. Nowhere under any law, you will find that there are 6 amendments because government was very prompt to plug the loopholes. If it has come to know about this, there is a shortcoming or there is some mischief going on, why not stop it immediately? Maybe in some cases with retrospective effect also. Looking at the nature of the process, because the process has a number of milestones. If you cross 3 milestones and you are on the 4th milestone, okay, from this date, this amendment act will be applicable to this stage. I think enactment of the code was certainly a radical reform. Especially in the it's a procedural law, especially in the procedural law. Shift in the paragraph, shift in the paradigm, shift in the process, shift in the jurisprudence also. Paradigm shift in the, I think it was not adversarial in nature. I will not say that this is inquisitorial also, but it is not adversarial in nature because it is not judicial supervised process. The whole process takes place outside the court, outside the NCLT, which we call it as an adjudicing authority. And thereafter, when COC approves the plan, and imagine the situation, how the judiciary has been proactive to help the validity of this, to oppose the validity of this code, but with the subject to the rider that no judicial forum, High Court or Supreme Court or the NCLT, they can intervene in the commercial wisdom of the plan. If the COC has approved the plan, then nobody can pinpoint that this is right or this is wrong because it's a commercial wisdom COC. For other things, for other violations processes, certainly judiciary can look at it and can pass orders as it thinks fit in the matter. But as far as the commercial wisdom is concerned, it cannot intervene. That means it is a market-driven process. Full flexibility has been given to the stakeholders. You can opt for corporate insolvency resolution process managed by insolvency professional. On failure of that, you can go for liquidation. Even in the liquidation, not the parcel of slump sale or parcel sale, you can go for a going concern sale also. That is also kind of resolution. If it fails because the plan doesn't meet the requirements under section 30, or the plan cannot be implemented, or somebody has violated, or corporate debtor has violated some condition of that plan, or otherwise, then if the plan is not can't be implemented, or there is a failure, or it is not passed within 100 days or 330 days, as the case may be, then certainly the failure of CRP or corporate insolvency process leads to liquidation. There is a liquidation. Your options: parcel sale or slum sale, or I should say going concern sale. So your option, and that same fellow RP is appointed as a liquidator who is conversant with the whole process, in what way to go. Even the security, I think the persons or the creditors, secured creditors, their option to refuse to be part of that. They can sell their own, they can sell their assets to that proportion of the security outside the process also, and inform. I mean, full flexibility has been given, choices have been given. You can go for compromise arrangement under section 230 of the Companies Act. You can go for corporate insolvency resolution process. You can go for fast track process. You can go for voluntary liquidation if there is no situation of inability to pay debt. You can go for liquidation also. So this is the law which provides full flexibility, market-driven process, professionally managed, and it provides for robust ecosystem. Regulator is there for laying down regulations, promoting the professionals. Then you will find that we have adjudicating authority, not the tribunal, though it is a tribunal, but it is termed as adjudicating authority. It is some certain limited powers. So it's not a tribunal as such, it's an adjudicating authority. And we have appellate authority as a National Company Law Appellate Tribunal, and then we have Supreme Court appeal before the Supreme Court also. High Court has been not being given any jurisdiction except under Article 226, which we have a basic structure. We have as a part of basic structure the Constitution, Article 226. You will find that under this law, there have been more than 400 resolutions within a period of 5 years. I think in the history of India, never under other laws you could find that there have been resolution or there have been recovery within 5 years. So 404 cases, all including 12 big cases, which we in the market call 12 dirty dozen cases, including that also. And secondly, we have more than 1,300 liquidations also. That shows that. One more thing I want to point out to all the law students here, that the purpose of law is twofold. One is implementation for achieving the object or desired goal. Other is compliances. This code and the regulations, together with the technology by information utility, this law provides for a good mechanism for disclosure as well as compliance regime, I should say. We have a disclosure regime daily. I think there is a time limit set. Every professional has to submit online all the details of the process. And there are 7 forms designed whereby he submits, and the IBBI gets the know-how about how the process is going on, where there is default, and there is alert system also and penalty also. Disciplinary action has been taken in 84 cases. You'll find that compliance mechanism, purpose of law is to, another thing is that purpose of law is to change the pattern of fashion of the behavior. Now we see that success of law is measured in 2 terms, either change in the behavior, or you will find that in the compliances. You will find that under this law, when it was implemented on the 1st of December 2016, the board was constituted 1st October 2016, and we started this functioning from 1st December 2016, the examination, all those things. You will find that there have been change in the behavior. People have started withdrawing the applications. They started one-time settlement. This is change in the behavior because they think that if we go for insolvency, naturally we'll be able to lose it. Okay, fine. We'll improve our behavior. They have come to one-time settlement and they have withdrawn the applications. Number of applications have been withdrawn. That shows the change of behavior. Number of resolutions have been done. This shows the success of the process. So I think this is the first law. Even the IPC, which was announced long back, I think during British times, of the law of the contract. But still, we find that those offenses are being committed and that the number is increasing. But as far as this law is concerned, I think behavioral change, robust compliance mechanism, robust disclosure mechanism, and disciplinary mechanism also. That you will find that this law, under this law, IBBI could do it, NCLT could also do it, but because of some infrastructure problem, many cases are lying before the NCLT they are waiting in, I think they are in queue for admission. I think in times to come, we will be able to enforce individual insolvency, where also we provide fresh start process for discharge of the liabilities of individuals who are having less income, low means of survival. I think there also we have a provision, and there we have individual insolvency also for partnership firm, proprietorship firm, and other individuals also. So I think very soon we will see the day of the light where these processes for individuals gets a good start, and all the citizens, I appeal to all the professionals, all the students, I appeal to the Jindal Global Law School to adopt a village. Can this law school adopt a village, because you have legal aid clinics, and through this legal aid clinics, the government has not commenced those provisions, but can we start, not these provisions, can we start as a good practice, because no law is complete without good practices being adopted by professionals. So can the Global Law School adopt a village where we see that we can help illiterate individuals or poor individuals or individuals in the remote areas who can get rid of the liability, or who can resolve their insolvency, individual insolvency after this act comes. After this act, the part 3 of the act comes into force. With these words, I thank all the participants present here, and I wish that in times to come, they will also contribute to strengthen further this insolvency regime of New India. Thank you very much.
Thank you so much, Dr. Vijayawargaya. That was an excellent overview and a lot of food for thought in terms of how we can clinically engage and take this forward, because the purpose of the research and the conversation that we're trying to table here is also about understanding data, understanding different stakeholders, and very lightly in terms of consumers and personal bankruptcy, as you mentioned, we do have a session planned for it to table that discussion and have that conversation. Taking forward from what you have enlightened us with here, we have Red Intelligence. Says two journalists from Red Intelligence, both legal journalists, Gausia Sheikh and Urmika Tripathi, who will be presenting today on the efficiency of the IBC with data and understanding why the IBC is much needed, addressing some of the open issues, and also making a case for insolvency resolution in specific sectors, particularly the spectrum conversation in the telecom industry, which will be presented today by both of them. Thank you very much for joining us, Gausia and Urmika today. Gausia is a legal consultant India with Red Intelligence. Urmika is legal consultant Asia with Red Intelligence, both insolvency law focused legal journalists. And over to you to make the presentation on efficiency and taking forward from what Dr. Vijayawargaya has just enlightened us for. Over to you, Gausia.
Thank you, Ashana. I hope I am audible.
Yes.
Yeah. Thank you very much for this opportunity. Thank you for letting us present our research and our work, and also, of course, for giving us a chance to collaborate with you. As a news and research platform, we're always happy to support initiatives like this. And kudos to you. We were there, a part of day one, and I must say it's been going really well. And thanks a lot. And at the outset, I must say it is quite a daunting task to follow somebody as eminent and eloquent as Dr. Vijayawargaya, but we will attempt to take this conversation a little forward. I'll just share my screen, Ishana, if that's all right. Is the slideshow visible?
Yes, it's visible.
Okay, thank you. Okay, so when the Insolvency and Bankruptcy Code was enacted in 2016, it was introduced as a game changer. And Dr. Vijayawargaya has rightly pointed out all the significant factors that led to this sort of an introduction. When it led to India's ease of doing business ranking shooting up, we lifted the IBC up on our shoulders as if it has just won the World Cup. However, sadly, the celebrations did not last very long. Soon, the law saw more criticism than praise. The two primary bones of contention being delays in resolution and low creditor recoveries. Now, when the IBBI released data on 5 years of the IBC, we at Red Intelligence decided to conduct some analysis of the data to understand whether there was any truth in these commonly heard complaints about the law. So we start with the first in terms of delays. Now, if we look at this chart, it might not seem very encouraging because it shows that around 79% of the ongoing resolution processes have been pending for more than 270 days. As we might know, 270 days used to be the earlier outer deadline for completion of resolution processes. Now, as Pam mentioned, it's 330 days. Now, while this may not be very encouraging, I think what we forget to do is that we do not look at it with the right perspective and the right context and background. So let's just talk about that background a little bit. First of all, when you compare it with the previous regimes, we find that winding up proceedings earlier, and as ma'am also mentioned, took more than 4 to 5 years to be completed. In comparison, IBC proceedings are well under the 2-year mark. So that is in a sense, some form of progress in terms of how the system has changed. Secondly, when you look at the enforcement mechanism, the key enforcement mechanism of the law, which is the National Company Law Tribunal, we see that at present, the NCLT is working at just about 54% of its full capacity. Add to that the fact that IBC is not the only law that the NCLT adjudicates upon. In fact, company law matters constitute about 58% of the NCLT's workload. This makes you wonder whether the IBC is greatly benefiting from even that half capacity that the NCLT is working on. Unsurprisingly, the Standing Committee of Finance, which recently studied the implementation of the IBC, has recommended that we have specific NCLTs focused on just IBC cases. We hope that this is a step in the right direction and would in some way contradict all the critiques of the law when they talk about delays in the system. Moving on to the second wide complaint that we see, low creditor recoveries. Once again, let's start with some data on that. Dr. Vijayawargaya mentioned the dirty dozen, which were the 12 large cases which were put into IBC by the Reserve Bank of India, the central bank. And we find that of the 9 companies that were resolved out of the 12, creditor recoveries as a percentage of the recoveries which creditors would have made had the companies been liquidated have far exceeded 100%, with Jyoti structures going all the way up to 387%. That again, I would say seems like a bit of a win. But now, before I move on to more data, let's just remind ourselves of something that we tend to often forget. The IBC is primarily a tool for resolution of stressed firms. It is a tool for reviving viable firms and for liquidating unviable firms. It has never been promoted as a mechanism for recovery. So in a way, I think it is a little unfair to the law to be judged on this parameter. However, even if we choose to do so, and that we have done. If we still look at the data again, until March of 2021, financial creditor recoveries were such that in comparison to actual claims, the recoveries were around 40%, while in comparison to liquidation value, they were around 180%. The 180 might not prick us as much as the 40% is a thorn in our side and on the loss side. But now again, we need to look at some more background. Before looking forward, we need to look a little behind. And we realize that a portion of the companies that were undergoing the resolution process were either sick, or they were defunct, or they had gone through multiple restructuring processes under the previous regime. Therefore, it may not again be very fair to judge the law at this stage. Or let's go a step ahead and say that, yes, okay, maybe you choose to judge it on the basis of these credit recoveries today. But we must not be hasty in passing judgment on it, because a large part of the IBC, a large part of its work has gone into just cleaning the audience tables. That said, not all is rainbows and sunshines when it comes to resolutions under the IBC. There are some criticisms for which, sadly, I do not have a counter argument. One of these is a consistent argument that not all sectors have fared the same way when it comes to smooth and straightforward resolutions. While the manufacturing and industrial sectors with tangible assets have seen relatively smoother resolution processes, there are sectors which have some unique functional requirements or have intangible assets. For instance, the aviation sector, a very large part of the functioning of an airline involves airport slots, which work on a use it or lose it basis. And then there's something like, again, the telecom sector, which also works on an intangible asset like spectrum. And the complaint and the recommendation when it comes to insolvencies under these sectors and similar sectors is that maybe it is time to give them some special attention and to use the unique features of these sectors that are inherent in the functioning of the sectors and imbibe some of it and streamline it with the IBC. My colleague Urmika will now take you ahead and take the telecom sector example under the IBC and elaborate on this issue.
Yeah. Hi, hello everyone. I think before I start, I just want to thank Ishana and everyone at Jindal who was involved in organizing this event. As Ishana and some of the other panelists I think mentioned yesterday as well, it is extremely important to have this dialogue and conversation amongst experts from both the theory and practice side of things. So yes, truly appreciate and grateful for the opportunity to be a part of this initiative. Now to start off, as Gausia mentioned, I will be discussing some of the legal hurdles or issues that have come up in insolvency proceedings of telecom companies like Aircel and Reliance Communications Limited under the IBC. These sort of showcase how the unpredictability in IBC processes due to litigation has led to severe delays. Now, discussions on how insolvency proceedings of telcos have fared assumes even more importance right now, given the recent news of Vodafone being one of the 3 major telecom services provider in India, also facing a credible insolvency threat. One of the main legal issues plaguing telco insolvency processes is questions around how spectrum usage charges, or what is broadly known as adjusted gross revenue, dues owed to the government for usage of the right to use spectrum, should be treated under the IBC. Now, before we get into the meat of the debate, I think it's important to understand what these AGR dues are. Broadly speaking, telcos are required to pay a license fees or spectrum usage charges to the Indian government in the form of a revenue share based on the calculated amount of their AGR. Companies and the government's Department of Telecommunication have been litigating about how this AGR should be calculated for more than a decade. While the telcos argued that AGR dues should only cover revenues from core telecom activities, the DOT insists that it should also cover income from non-core activities such as interest and dividend payments. In October 2019, the Supreme Court settled the debate in favor of the Department of Telecommunications. Its verdict meant that telcos had to cough up close to, I believe, INR 920 billion to the government, the calculation of which is still being litigated before the Supreme Court as we speak. Now, getting back to the main legal issue in telco insolvencies, which has come up before various insolvency tribunals, and the question is, how should such AGR dues owed to the government for the license to use spectrum be treated under the IBC? To put it into context, we need to understand that the core asset of a telecom service provider is its license or right to use spectrum. Technically, the company does not own the spectrum, but merely has a right or license to use the spectrum to provide telecom services. Question is, can the spectrum, which isn't exactly owned by the insolvent company, be transferred to the successful bidder as part of an IBC process, especially when there are pending AGR dues against the company? Moreover, should AGR dues owed to the DOT or the Department of Telecommunications be treated as an operational debt or a financial debt? Now, I think this was discussed yesterday as well, but just a quick recap. Debt under the IBC is largely classified into two heads, operational debt and financial debt. Operational debt is owed for any debt owed for providing goods or services and also includes government dues. Financial debt is debt extended against the time value of money, so your typical bank loans would fall under that head. Now, the difference in how these AGR dues are to be classified is critical because financial creditors have an upper hand in the insolvency processes under the IBC, and this was a very conscious policy decision. Moreover, while OCs are promised a certain minimum liquidation value, amounts that they would recover if the proceeds offered by the successful bidder were distributed as per a statutorily prescribed liquidation waterfall, their ranking in the liquidation waterfall means that the liquidation value is often nil. So even though the law is pretty clear on the fact that government dues fall under the head of operational debt, various government bodies have unsurprisingly challenged this because they are likely to make minimal to no recovery if they accept their position as operational creditors. Now, the Supreme Court was faced by these very specific questions relating to AGR dues, but it ultimately delegated the issue back to the the Insolvency Appellate Tribunal in India in September 2020, citing jurisdictional grounds. In April this year, the NCLAT, which is the Insolvency Appellate Tribunal, passed a ruling on these issues, and it went on to rule that while the spectrum license is an intangible asset of telecom companies, it cannot be transferred in an IBC process without the clearing of the pending AGR dues. And they cited the spectrum trading guidelines to back their position, to say that spectrum trading guidelines require clearance of past dues in order for that license to be transferred. So while on the one hand, the ruling confirmed that payments owed to the DOT should be treated as operational debt, on the other, it sort of accords them a higher priority than what is set out for such obligations under the IBC by requiring them to be cleared in accordance with the spectrum trading guidelines. Now, this ruling has led to some important questions in the market. Given the overriding provision in the IBC some ask, which basically provides that IBC provisions override any conflicting provisions in other laws, shouldn't the bankruptcy law's treatment of crown debt prevail over the DOT's spectrum trading guidelines? Even if the NCLAT's intention is to accord priority to the government claims relating to, say, concessions for use of natural resources, arguably the IBC currently doesn't treat such outstanding payments differently from any other operational debt. So yeah, this ruling led to a reaction in the market, and these are some of the questions that have come up. I believe this order is currently under appeal before the Supreme Court, and everyone will be waiting for the verdict, not just because of its possible impact on ongoing telco insolvency processes, but also because it could even have an impact on insolvency of other concession-based sectors, such as power or mining, because government bodies there could use the same argument to say that you don't own the asset, you merely have a right to use it, and hence our dues should get priority. So yeah, that's one of the main things that has come up in telco insolvency processes in India. Now, coming to the second issue, which has plagued telco insolvencies, in August last year, the Reserve Bank of India, which is India's central bank, rejected UV Asset Reconstruction Company's bid for Aircel Limited on grounds that SARFAESI, which is the primary legislation which governs asset reconstruction companies in India, only permits ARCs to engage in the business of asset reconstruction or securitization and does not allow them to act as bidders under the IBC. UVARC, on the other hand, argued that IBC expressly contemplates ARCs as a resolution applicant in corporate insolvency resolution processes. Now, this again is pending before, I think UVARC challenged the RBI's position before the Delhi High Court, and I believe the matter is still pending there. In one of the hearings, the Delhi High Court directed the different ministries and the central bank to arrive at a consensus on this apparent conflict between the IBC and the SARFAESI. And RBI, I believe, has also formed a committee to review the working of ARCs in the financial sector, including their role in the resolution of stressed assets. So there's hope that there will be a finality to this issue, at least once this committee comes up with this with its recommendations. Now, while the issue of ARCs bidding in CIRPs will have an impact on other sectors as well, because they're free to bid, they could have bid in other sectors as well. The reason we discuss it here in the telecom case study is because the outcome of this dispute will also be critical to the other major telco which is undergoing insolvency, being Reliance Communications, because UVARC has emerged as a successful bidder in that process as well. So yeah, these are the two main issues that we wanted to discuss in terms of legal issues that have come up in IBC processes of telcos. And that brings me to the end of this. And as I mentioned, I think the market will be keeping a keen eye on these proceedings, especially given the potential ramifications on any future insolvency of not just concession-based sectors, but also telcos, with Vodafone being in the news for that right now. So yeah, that's the end of what we wanted to speak about today.
Thank you so much, Garcia and Mita. I think one of the biggest aspects of understanding legislation is data, and what you just brought to the table basically allows for the conversation we had yesterday about needing empirics to actually analyze efficiencies of the law and not really judging it prior. Yes, there are concerns and issues that are being raised that we have discussed, as the secure creditor rights that we spoke about yesterday, which is a paper authored by both of you and Suharsh. And the next paper that we have lined up today in terms of the interplay of specific laws, such as the Arbitration Act and RERA, which is the next session as well. So that puts a lot of things in perspective and allows us to start the show with the next 3 sessions as well. With that, let's move on to the second paper of the JGILS launch platform, written by Abhishek Saxena of Phoenix Legal and being discussed by Dr. Omar Salah from Norton Rose Fulbright and Dr. Meng Seng, who's an associate professor at National University of Singapore and the co-director of the Asia Law Institute.